Hi, everyone. This is Mary Ann Harvey from Court Improvement Project. I think we're going to go ahead and get started. I'm sure that people will continue to join us. I wanted to just go over a few things before we start. So first of all, welcome to the webinar. We're really happy to be able to host this along with some of our partners. So as you can see on the screen, we'll be presenting with Sarah Helvey from Nebraska Appleseed, Juliet Summers from Voices for Children in Nebraska, Steve Green from DHHS, and Jeannie Bradner from the Administrative Office of Probation. And so I wanted to go over just a few of our housekeeping things before we get started. First of all, if you could mute your phone or your speakers by either pressing the mute button. If you're on your phone, you can press *6. Or on your computer at the top of the webinar, there's a microphone. Just make sure that that's muted. If we start getting a lot of feedback during the webinar, Tracy may have to mute everyone, in which case presenters will just have to unmute yourself before you get started. Next, as you'll see at the bottom right-hand corner, there's a chat box. Feel free to ask questions in that chat box as we go along, and we will monitor that. If you need CLE credit for this webinar, be sure to sign in with your full name. And if you're watching as a group, please write everyone's name who's watching with you into the chat box. That's the way that we can send in the information. I see that there's a question, is there a way to mute from within the app? I think that there should be a microphone button at the top of the screen that you can mute. Or just push mute if you're on a phone. And then we have some resources available in the download box. So that's the box that's called Files, and that is at the top of your screen on the right. And that has a legislation chart with all the bills that we're going to talk about and a lot more. And also a breakout of LB 354. So feel free to download those. So I think we'll go ahead and get started. And I went into more detail on how a bill becomes a law in the unicameral at the last webinar, so I'm not going to go into as much detail. But just as a reminder, in Nebraska, we have a unicameral legislature, which is one house. Each bill that's introduced is referenced to a committee and gets a public hearing. After the hearing, the committee can vote on the bill and send it to the full legislature to vote on. And then there's a process that they go through within the legislature body. The governor, after a bill is passed on final reading, the governor then has 5 days, excluding Sundays, to decide what to do with the bill. He can sign it, line item veto the bill, or veto the bill. And then the legislature, to overcome a veto, would have to have a vote of 30 members. A bill becomes a law 3 months after it's signed, unless there is an E clause with a specific date that it goes into effect. And so we will highlight that as we talk about bills, if there are any bills that have an E clause. The session is a biennium, so there's a long session, which we just finished, and that's in odd numbered years, and then a short session in even numbered years. So that'll be next year, 2020 will be a short session. The committees are elected in the long session, so the committees that were elected this year, they'll stay the same for next year. And bills can hold over into the next session of the biennium. And so some bills that were introduced in 2019 have the chance to come back in 2020. So we might see some repeat bills come to us. Okay, so I'm going to go ahead and talk about some of the bills that passed this year. You can see those up on the screen. So LB 154 was a bill from Senator Brewer, which requires the State Patrol to make a study to determine how to increase resources for reporting and identifying missing Native American women and children in Nebraska. So the Commission on Indian Affairs is to convene meetings with tribal and local law enforcement partners, federally recognized tribes, and urban Indian organizations to determine the scope of the problem, identify barriers, and find ways to create partnerships to increase reporting and investigation of missing Native American women and children. Um, this was signed by the governor in March, and the report is to be submitted by June 1st, 2020. And this is something that I think nationally we're seeing more and more attention focused on. And so we'll be watching what happens in Nebraska. LB 199 was a Senator Wishart bill, which increases the appropriation of funding to CASA. And it used to be $300,000 and now it is $500,000. And so that was passed as part of the budget. LB 281 was a Senator McAllister bill, and that allows each public school to post a sign in English and Spanish that includes the Child Abuse and Neglect Hotline, or put a link to it on the website. And so NDE can also contract to create a poster for that. LB 519 is a package of bills that passed. So this was originally a Senator Slama bill, but it also includes portions of LB 458, 479, 516, and 517. And this bill has to do with sex and labor trafficking in Nebraska. So the bill adds a definition of child abuse where a child is exploited through sex trafficking into the criminal code, as well as into the Child Abuse, Child Protection and Safety Act. It also states that when DHHS receives a report of sex or labor trafficking on minors, it's required that DHHS assign this report for an in-person investigation and coordinate with law enforcement, the child advocacy centers, and the investigation team. It also requires DHHS to develop assessments for children and young people who have been sexually trafficked, and to adopt rules and regulations related to investigations of sex or labor trafficking. DHHS must also provide a report to the legislature, governor, and the attorney general of the availability of services for victims of sex or labor trafficking by December 1st of 2019, and requires that there be tracking of data. The abuse can include when the perpetrator is not a member of the victim's household, no longer has access to the victim, or is unknown and cannot be identified. So that's something that is a change from prior statute. And then LB 619, a Senator Kolowski bill, requires that insurance cover behavioral health services delivered in a school. And there was a delay on implementation for this bill. It won't go into effect until January 1st of 2020. And the bill says that notwithstanding statute, an insurer offering a health insurance policy shall not deny coverage or payment for mental health service solely because the service is delivered in a school. And this is just to clarify for children and young people who receive mental health services in a school setting that insurance can still pay for that service. Okay, before I go on to talk about some of the interim studies, just one clarification that bills go into effect 3 months after the end of session. And I said 3 months after they were signed, but Jeannie brought that to my attention. So I just wanted to mention that. So in the off season, so in the summer and fall, mainly the fall, the legislature investigates different things that are of interest to committees or senators. And so these are called legislative resolutions, and I wanted to talk about a few of them. The first one is LR 88, which is from Senator McAllister. And this is an interim study to examine issues related to grandparents raising grandchildren and other kinship family relationships. The resolution goes on to state that 40% of Nebraska children in out-of-home care are living with relatives. And so we need to look into the situations a little more. And so the study shall include, but not be limited to, an examination of the creation of a kinship navigator program through FFPSA, a review of barriers facing grand families and kinship families, both in and outside the child welfare system, and the identification of resources to support grand families and kinship families. And this is assigned to the Health and Human Services Committee for this study. And then LR 134 is from Senator Slama. And the purpose of this study is to examine the drug testing protocol recently changed by the DCFS of the Department of Health and Human Services for families involved in the child welfare system. And specifically, the study should look into the reasons the drug testing protocol was changed, other states' experience with drug testing protocols, the lack of drug testing for initial assessments and structured decision-making safety and risk assessments, the use of a new drug testing protocol in high-risk cases, and the decision not to drug test members of families subject to a safety plan, even if substance use is present, the lack of substance use disorder evaluations when at the SDM outcome is safe or conditionally safe, the decision not to drug test infants and children who may have been exposed to drugs, the number of families subject to a safety plan who have been moved into a court-involved case or have had children removed from the home due to substance abuse in the home, current laws related to drug testing policies in the child welfare system, the number of children placed out of home before the drug testing protocol change compared to the number of children placed out of home after the change, the number of children who tested positive for drugs prior to the drug testing protocol change, the impacts of possible drug use on children after the drug testing protocol change, the number of drug tests performed on children and adults prior to the drug testing protocol change compared to the number of such tests after a change, and the process for holding parents and guardians accountable under a safety plan or case plan, and the efforts by the department to find a compromise with stakeholders regarding drug testing protocols. And this interim study was also assigned to the Health and Human Services Committee. And then last, I wanted to talk about LR 177, and I noticed there's a typo on the chart there that says 144, but LR 177 is an interim study to examine issues faced by youth in the child welfare system who are pregnant or parenting. And so this study is going to look at the number of youth in the child welfare system who are pregnant and who are parenting, the availability of private and public support services of such youth, the use of private and public support services for such youth by DHHS, initiatives, programs, and policies implemented in other states that have improved outcomes for parenting or pregnant youth, and the impacts of FFPSA on the delivery and availability of service for pregnant and parenting youth. And it's also to include the perspectives and experiences of youth who are or who have been a part of Nebraska's child welfare system, and intergenerational strategies to stop the cycle of involvement in the child welfare system. And this LR is also assigned to the HHS committee. If you download the post-session chart, you'll have all the information about LR 177 in there. So now I'm going to turn this over to Mary Pat to talk about some more bills.
Well, not a whole lot passed this year in regards to juvenile justice. However, LB 390 by Pansing Brooks passed this year, and it relates to the safety of students and staff in school. One issue, it specifies that parents are to be notified as soon as reasonably possible when a student is in contact with either a school official or law enforcement for disciplinary reasons. It also is going to have schools and law enforcement basically have MOUs in place that are going to spell out responsibilities of each. Basically, that the school administration, they're in charge of school disciplinary matters, and SROs are law violations. And just from scuttlebutt, I've heard that law enforcement is in favor of that because they don't they don't want to be there just for disciplinary issues of school-related things. They want to make sure it's just law violations. The other LB 478 by Senator Vargas relates to sexual assault in minors. And the new law states that consent is not a defense in a civil action arising from a sexual assault in which a victim was under 18 and the perpetrator was an adult in a position of authority. The statute is going to define such terms as adults in position of authority of youth, undue influence, and vulnerability of the victim. The legislative resolution that I was interested in is from Senator Vargas. It's LR 201, and the purpose of the study is to examine the role of truancy and what it plays in the school to prison pipeline, and explore possible alternatives to reduce truancy and ensure that students are successful in their education ventures. The study is going to include state policy and services regarding to truancy, national best practices, exploring pathways, alternative programs that could be available for youth, and factors that are contributing to youth truancy. And they also want to look at best practices in assessing the risks and needs of youth and implementing policies that reflect the desire to help youth succeed, and also looking at the extent to which truancy contributes to the school to prison pipeline. And that is really it for my piece. Who is next? Sarah, you are up.
Thanks, Jenny Pat. This is Sarah Helvey, and I am a staff attorney and director of the Child Welfare Program at Nebraska Appleseed. Appleseed, I think most of you know, and I was on at the beginning of the session, but just for those of you who may not know, Nebraska Appleseed is a legal advocacy organization based in Lincoln, but we do work statewide. And I'm going to go over a couple of child welfare bills and interim cities that we were involved with this year. And the first one that you can see there on your screen is LB 328, and it was introduced by Senator Kate Bowles and referred to the Health and Human Services Committee. This bill did not pass. I'll talk about that a little bit more, but just want to say before I jump into it, so you're not trying to track what is going to be law soon, but because as Mary Ann said, this is the first session of the biennium, this bill is still in committee and could move forward next session. So what this bill, the intent of the bill, is to implement the Federal Family First Prevention Services Act, which passed about a year ago, into Nebraska statutes, including provisions related to the state option to draw down federal Title IV funding for prevention services, including substance abuse and mental health for children and their parents or kin caregivers who are candidates for foster care is the federal term. And it the bill defines that, would have defined that more specifically into state statutes for Nebraska. The bill also included provisions related to, and if you're familiar with the Federal Family First Act, the other big bucket is with regard to the placement of children in qualified residential treatment programs. That's a new placement setting called QRTP, where there has to be an assessed treatment need for placement in that congregate care level in order to receive federal funding, and also court findings related to that placement. And so then the bill also has some provisions related to voluntary or non-court involved cases, which now represent about half of all system-involved children, but there's not currently any statutory authority or statutory reference really to those cases, so it would have put some statutory framework around the voluntary and non-court involved cases. And then LB 328 also extended the family finding pilot. As I said, it didn't advance out of committee. To be honest, I think it was a little bit overwhelming for senators, or for the committee. It was 38 pages long, and a lot of detail about the federal law. So the Department of Health and Human Services is going ahead with the implementation of the Family First Act in Nebraska. They have a draft of their prevention plan, and will proceed with the implementation of that, I believe, starting in October of this year. So I know a lot's going on with the department and that's moving forward without the legislation. But as I said, it doesn't necessarily preclude the legislature from revisiting that in the future. And as I'll mention on one of the future slides ahead, Senator Bowles has introduced an interim study, which is LR 193, so the legislature can continue to look at the implementation of the Family First Act here in Nebraska. Okay, and then I think I'm ready for next slide. Can I do that, or can so? Thank you. So then at the top there is one more LB, one more legislative bill before I talk about the LRs, the Legislative Resolution Interim Studies. I wanted to talk about LB 600, which was originally introduced by Senator Lynn Wall. LB 600, as originally introduced, made changes to the Office of Public Counsel with regard to veterans institutions. But more relevant to child welfare, portions of LB 330 and 332 were amended into LB 600. LB 600 had the priority designation of the Executive Committee, and it passed with the amendments. So these are all law that will go into effect, as Mary Ann mentioned. So first, LB 332 was originally introduced by Senator Kate Bowles. And it made some, I would say, smaller changes to the Bridge to Independence program. I think probably most people know that's our extended foster care to 21. Made some changes that were recommended by the Bridge to Independence Advisory Committee, which sits under the Nebraska Children's Commission. Those changes include permitting eligibility for young people who were guardianshipped after age 16 and then the guardianship disrupted, and a petition was filed under 43-247 sub 8 for disrupted guardianship jurisdiction. It also permits eligibility for young people who were adopted at age 16 or older. Those young adults can now choose either to receive extended adoption assistance or to enter into the Bridge to Independence program and receive casework support and that monthly stipend directly. And then it essentially eliminated eligibility for young people who are not residents of Nebraska unless they were placed in another state under age 19 through a ICPC, through an interstate compact. That is something that I think was not realized early on in the program, that the federal law requires monthly caseworker visits, face-to-face caseworker visits. I think we thought that that could be handled electronically, or and there's been a lot of work to have other states supervise those, but it wasn't able to happen across the board, and so there was a significant cost of caseworker travel for those out-of-state use. So now there is a residency requirement, except through ICPC. And just a note, I'm not an expert on this, but I think there was some discussion that students who are out of state for school may still be residents of Nebraska for higher ed purposes. So that's something, if you have a student or a young adult in the Bridge to Independence program in that situation, to further look into. The bill also eliminated a duplication in services for young adults receiving DD services under the Medicaid waiver. And then finally, the bill requires juvenile courts to make a reasonable efforts finding in B2I hearings that's necessary to draw down that federal Title IV funding. And then the second bill I mentioned that was amended into LB 600 was originally LB 330, originally introduced also by Senator Kate Bowles. The original version of that's about the Nebraska Children's Commission and continuing that. The original version was a little bit more complicated, but the final version that was amended into LB 600 essentially eliminated the sunset for the Children's Commission. So that the Children's Commission will continue, but I think that all current terms expire, so they're, I believe, taking new applications. If you're interested in serving on the Nebraska Children's Commission, you can complete an application online, just a public service announcement. And then finally, I wanted to mention there's 3 LRs there, and I already mentioned LR 193, that's the interim study to implement the Family First Act in Nebraska and to identify opportunities for children and families. With regard to LR 127, that was introduced by freshman Senator Megan Hunt. It's regarding the rights of youth in foster care in the juvenile justice system, to understand their rights, have them upheld, and to explore the need for additional rights. this really grew out of some of the work of the Strengthening Families Act Committee of the Nebraska Children's Commission, which I serve as co-chair. And there was a subcommittee that developed a Youth Bill of Rights as part of the federal Strengthening Families Act requirement that youth get notice of their rights at age 14 or older. We have a youth fellow at Appleseed, Bobby Taylor, who's been really involved with this, and we hope to have other youth and partners continue to be involved with Senator Hunt in that interim study looking at further at that issue. And then finally, LR 239 was introduced by Senator Sarah Howard as chair of the on behalf of the Health and Human Services Committee to examine non-court involved cases, including voluntary and alternative response cases in the child welfare system. And as I mentioned previously, and all of you know from your work in the system, this is in a response to a significant pendulum swing to more diversion, foster care diversion, and wanting to kind of monitor that as part of this interim study, LR 239. So with that, those are some bills and interim studies that Appleseed has been involved with and will be monitoring. And I think the next presenter is my friend, Juliet Summers.
Hey, this is Juliet. Can you guys hear me okay? I'm going to take that as a yes. So yeah, thanks, Sarah. I'm Juliet Summers. I'm with Voices for Children in Nebraska. I'm going to talk to you about a couple juvenile justice bills, which are a little bit more detailed and technical in nature, and then touch on just a couple things that are still waiting for the summer interim or a possible new life next session. So I'll start with LB 354, which is an update to our record sealing laws that pertain to minors charged in juvenile or county court. I think probably everyone on the call knows why appropriately sealing juvenile records is just so crucial. Teens make dumb choices, and they tend to grow out of risky and antisocial behavior. But if there's an unsealed juvenile record hanging out there, it can really be a true barrier to moving forward with education or career, even things like housing opportunities. So LB 354 was introduced this session, grew out of an interim study that Senator Pansing Brooks had sponsored last summer, looking at our current record sealing statute and how it is working or not working for juveniles. What really came out is that even though we've had our current sealed record statute for some time, a sort of astounding number of juvenile cases just haven't been getting sealed as intended by the law and as promised to young people. So UNO's Juvenile Justice Institute had worked with Legal Aid's Reentry Project on a study of juvenile record sealing, and they found that between 2012 and 2015, only 43% of cases where the youth was under age 18 when the offense occurred were getting sealed. And Dr. Hobbs with JJI had done a reexamination in 2018 and found that across calendar year 2017, out of over 12,000 cases that had closed and could have been sealed, only 20% were actually sealed. And she also examined cases where that were auto seals, where the charge was dismissed or dropped under our current law, and of those, 65% had been sealed. So still not great, not 100%, which it should have been, but a big improvement difference between the auto seal cases over the non-automatic sealing. So Senator Pansing Brooks worked with a number of interested parties over the course of the fall in drafting, and as a result, the bill had really pretty broad support at the public hearing in January. So there were youth advocates, juvenile court practitioners, diversion coordinators, both defense attorneys and county attorneys all came out in support. And it's really a cleanup to ensure that the statute holds true to its promise, but there are a lot of technical parts to it, which the Court Improvement Project has helpfully laid out for you here in a separate document. And I'll go through some of them, hopefully in the same order that they're here for you. So first, we were hearing from diversion coordinators that sometimes they're asked about prior diversion involvement or even current diversion involvement, and it wasn't totally clear what the duty of diversion was to respond or not respond to those inquiries. So the bill clarifies that apart from certain authorized individuals, such as law enforcement, who need to know, diversion should respond to public inquiry as though a youth has not been involved with diversion. Next, the bill adds a category of sealing eligibility for cases that start in county or district court and then are subsequently transferred to juvenile court for ongoing jurisdiction. So if the juvenile case eventually gets sealed down the line, the original county court or district court case and the related charging documents, et cetera, can also be sealed. That wasn't previously in our record statute. The bill also provides for retroactivity, such that if an adult now realizes that their record could have been eligible for sealing under these provisions, they can notify the county attorney or they can motion the court requesting that their record be sealed, and there's provisions laid out for that. There are some updates to automatic sealing eligibility. So you are, a young person is eligible for automatic sealing of their record when the offense occurred when they were under the age of 18, and there are a few options. There was no juvenile petition or criminal complaint filed. So, an offense occurred, maybe there was a citation, but nothing was filed from it, automatic sealing. A juvenile agreed to pretrial diversion or mediation and satisfactorily completed it, auto seal. Charges were filed but were later dismissed by the court. This is supposed to be automatically sealed. And then the big change or big addition is the addition of automatic sealing when there is a petition in juvenile court or a complaint in county court and the juvenile has successfully completed the orders of the court or the terms of probation or treatment or rehabilitation program. This record will now be automatically sealed on successful completion. That had already been the practice in some courts and jurisdictions. I think that's been the practice in Douglas County for some time, and now that will be statewide the law. So next, the bill also provides a new pathway and process in cases where a record has not been automatically sealed. So if they were supposed to be sealed under one of those provisions that I laid out before and they weren't, then the individual or the parent or guardian can provide notice to the county attorney or motion the court, and the CA or court shall seal it. But if the records were not sealed because, for instance, the youth didn't successfully complete probation, the bill lays out a new timeline and sort of modifies the process a little bit for motioning the court to seal it at a later date. So at 6 months after the case was closed, or when the individual reaches the age of majority, whichever is sooner, the youth or his or her parent or guardian may file a motion in the court of record. And that motion has to set forth facts supporting the argument that the subject of the record has been satisfactorily rehabilitated. The court will then promptly notify the city or county attorney and Health and Human Services if Health and Human Services was an appropriate party to the case or the young person was a ward. Any party notified may file a response with the court within 30 days. They don't have to, but if they do, it needs to be served on all parties. And if the response is an objection to sealing, it needs to specify which statutory factors form the basis for objection and set forth facts supporting the argument that the individual has not been satisfactorily rehabilitated. If there's not a response, or there's a response but no objection, then the court shall seal the record. If there's an objection, then a hearing is to be set within 60 days. And at this hearing, the burden is on the filer of the motion to show satisfactory rehabilitation. And the court will consider, these were statutory factors before. A couple previous statutory factors were eliminated, the age of the juvenile and the underlying charge. Those are no longer factors to be considered. But this court will still consider the behavior of the juvenile after disposition, adjudication, diversion, or sentence, and also the response to diversion, mediation, probation, supervision, et cetera, the young person's education and employment history, and any other circumstances that relate to the rehabilitation of the individual. The respondent who filed the objection can set forth their facts as to why that burden hasn't been met. But the court has to find, by preponderance of the evidence, that the individual has satisfactorily rehabilitated. And if that decision is yes, enter the order to seal the records. If no, then the juvenile or the parent or guardian has to wait a year to make another motion to seal, but the court can still waive that time restriction. Final couple little notes on this one. Any sealing order has to be in developmentally appropriate language. The Supreme Court is asked to develop model language for notices and orders. And the order has to contain contact information for the relevant government agencies that will be affected by the order. So this gives the young person the tools they need to do their own follow-up to ensure that all records are actually sealed as promised. And finally, the bill clarifies that even when a record is sealed, it's still accessible by the individual who's the subject of that record and by any persons authorized by them. We sometimes see cases where an adult might want to go back and demonstrate what, for one reason or another, what happened with them while in probation, and they should just always be able to have access to their own file, and the law does require a proof of identification. It also allows the Supreme Court administrator to authorize use of sealed records for bona fide research with confidentiality protection, and it makes a knowing violation of violating the sealed record statute a class 5 misdemeanor rather than a contempt proceeding. So that was kind of a lot. I don't know if we're saving questions for the end. Let's see. I have a question here. You talk about these cases being automatically sealed, but the county attorney can still object, right? So the only thing that happens automatically is the process of sealing. I think it depends on the circumstances you're talking about. So the change to the law is pretty clear that if the young person has satisfactorily completed their probation or their orders of the court, that it is automatically sealed by the court. So I think the appropriate time for objection by the county attorney would be related to the question of the young person satisfactorily completing the terms of their probation. So if a young person has not been following the terms of their probation or their court orders for rehabilitation, et cetera, then filing a motion to revoke or pursuing an extension of the probation order, et cetera, to make sure that happens. Because by my reading of the bill, I don't see that there's, under that set of circumstances, that the young person has successfully completed, that there's left a window for objection in that process, at least by my reading. Are there any other questions on this one before I move on? I would make a final note for practitioners that I think I mentioned them earlier, but Legal Aid of Nebraska has a juvenile reentry project that assists young people under age 24 with reentry after involvement in juvenile justice, and that includes with record sealing. So that is a great resource. They may be only for Douglas and Lancaster County, I'm not totally sure, but if you have former clients who need some assistance, they're a really terrific resource in that regard. So the next bill I'm going to touch on is LB 595, the Senator Albright's bill. I believe she received the bill. It was brought to her by the Administrative Office of the Courts and Probation, and specifically the Office of Dispute Resolution was a strong supporter of this bill. So it's intended to infuse greater access to and utilization of restorative justice processes in Nebraska court proceedings, including in juvenile court. So for those who might not be aware, restorative justice is an alternative mode of dispute resolution, which seeks to repair harm done to an individual or a community, usually through mediation that creates direct and immediate accountability for the offender. There's a lot of research that's been done around the world that really supports restorative justice as highly effective, particularly at improving the experience of the justice system for victims, but also for improving outcomes such as reduced recidivism for juvenile offenders. So restorative justice asks who has been harmed, who created the harm, and how can that harm be repaired. And usually RJ practices involve some form of voluntary confidential mediation, ideally between the victim and the offender and their supporters. Sometimes the victim surrogate comes if the victim is not willing to or not able to. And the goal is to create a plan for the offender to make things right for the victim or the community. So LB 595 essentially broadens the mission and purpose of the Office of Dispute Resolution to explicitly include restorative justice and to support the expansion of centers that practice it, to promote public awareness of it, and also to analyze and evaluate restorative justice programs in Nebraska. As it pertains to juvenile justice, the bill specifically allows for restorative justice to be used as part of a school attendance plan to address barriers to student attendance, as a response to student behavior under the Student Discipline Act, in diversion, or as part of a plea bargain on a juvenile petition or a county court charge with a minor, and also as a condition of disposition or an order of the juvenile court. So I would note that there is some conflict here because restorative justice really requires voluntariness of all parties, including the offender. I think the way the bill gets around that a little bit, the language of the statute is the court may order the juvenile to be assessed for referral to participate in a restorative justice program. And so my hope and assumption would be that part of that assessment by a restorative justice center or mediator part of that assessment is voluntariness. If the juvenile's just not willing to do this, it's not going to be a useful exercise for them, and particularly probably for the victim. It could create harm rather than repairing harm. So we'll want to be really careful about that. The bill clarifies that proceedings and statements made in connection with the matter referred for restorative justice and the underlying controversy or dispute are confidential and privileged. So, but there are some exceptions. If all the parties agree in writing to waive that confidentiality requirement, that's one. Statements made in connection with a restorative justice proceeding can be used as rebuttal or impeachment evidence in a future juvenile adjudication or any criminal proceeding. So defense attorneys, as you're thinking about advising your client whether or not to participate in one, if you have one, that's something to be aware of. Statements can also be used at sentencing or during juvenile disposition proceedings. And then also some sort of protective ones if there's a later action taken against a facilitator, or if the statement was made in furtherance of crime or fraud, or if it's a mandatory reporting situation. So, a new allegation of child abuse or neglect not previously known or reported is coming up in a restorative justice proceeding. Obviously, that there's exceptions for confidentiality there. Or there's kind of a broad bucket. There's some other conflict with other legal requirements. So after the parties have done this restorative justice mediation, a reparation plan is created, and it needs to specify provisions for, what reparation is going to be made, how it's going to be monitored, what completion will look like, and how that's going to be reported back to the county attorney or the court. So if restorative justice is being used for diversion or a plea bargain and a reparation agreement is reached, then the facilitator is required to forward that to the county or city attorney. And then they also are required to give notice to the city or county attorney regarding the juvenile's compliance with the terms of that agreement. So if it's not satisfactorily completed, then the city or county attorney can take action by referring the matter back for further restorative justice or by choosing to file the charge. But if the juvenile meets the terms of the agreement, then the county attorney shall follow through by either not filing the charge or filing a reduced charge if it was part of the plea negotiation. That's all I've got on 595. So I will, there's a couple other things coming up that are on my list for you to be aware of. LB 231 is Senator Pansing Brooks's automatic early appointment of counsel in juvenile cases bill. This has been around the block a few times. It's out of committee. It's fair game for general file floor debate early next session, as is LB 230, which is her bill providing restrictions and administrative requirements on room confinement of minors in government facilities. That's on, if you want to turn the next slide. Thanks. And then next year, also up early for debate, is going to be LB 147. So this is Senator Groney's bill to authorize use of physical contact or intervention by teachers on students. and to allow for removal of students from class for unruly behavior. And it has a pretty, as originally drafted, had a pretty broad immunity clause for school personnel in these cases of removal or physical contact. There was some high drama at the legislature on this bill late in session, but it eventually was pulled out of the Education Committee, and because it has a priority designation, it will come up early next session. So Senator Pansing Brooks, along with, I think with her, it's 40 out of the 43 senators, introduced LR 208, which is an interim study regarding appropriate responses to student behavior and mental health needs in schools, essentially trying to create a negotiating space this summer related to this bill, where teachers, administrators, youth advocates, disability advocates, education lawyers, everyone interested in this bill can come together to talk about how to support schools in managing behavior and responding to increasing concerns about student mental health needs, recognizing that LB 147 is going to be up for debate early next session. And then the last two interim studies I wanted to mention are both related to the YRTCs and how they should be staffed, managed, what programming should be offered, how they should be, what amount of funding is required. Those are LR 103, Senator Lowe, and LR 200, Senator Quick. And I think that's all for me.
Well, good afternoon, everyone. I assume that you can hear me. This is Steve Green. I have the privilege of being a part of the Department for Health and Human Services Division of Children and Family Services. I am a deputy director and am new to Nebraska, coming from a bicameral opposed to unicameral. This has been a learning curve for me, for sure, this past session, but I have greatly enjoyed the process. And so I haven't met a lot of you face-to-face, but as I please, I hope if you need contact information, feel free to give me an email or call. Love to talk if there's any questions that we're not able to address or because time doesn't permit here with the bills that I'll be going over. So just wanted to make that clear. We had sort of a package of bills that we presented as part of our legislative agenda for LB 46, or excuse me, for the 2019 session. However, before I get there, Sarah had mentioned the family FFPSA bill, and I don't know if you all know this or not, but and this was very exciting news for us, but they have actually posted the 4E clearinghouse. We just saw a memo that went out a little bit ago, so it's Title 4E Prevention Services Clearinghouse with a list of programs that are that have made the clearinghouse, and so I would recommend you all taking a look at that if you get a chance for those that are interested in Family First Prevention. It looks like it was brand new today. The first bill I wanted to talk about was LB 460. 460, and I'm going to kind of group them together because the 460 and 459 were rolled into one package as 460. This was a HHS committee bill that included not only our implementation for fingerprints or background checks for child caring agencies, which was to help us be in compliance with implementing FFPSA October 1st of this year, so in just a few months, but it also addressed a couple sort of federal mandates that were done in via the 2014 Child Care Development Fund block grant reauthorization, and through our through that, we were supposed to address the transitional child care assistance and then also child care licensing. So I want to talk about those two first. So first, the transitional child care assistance. In 460, the bill changes eligibility requirements with regard to the federal child care subsidy program. Importantly, in determining ongoing eligibility, if a family's income exceeds 130% of the federal poverty level, the family would be eligible for transitional child care assistance. Through the remainder of the family's eligibility period until the family either exceeds 85 SMI or 185 FPL. So just this transitional period or area or range that a family would be making its way or transitioning into transitional child care. So there's that. There's a 24-month limitation for families with children to receive cash assistance for work-related child care expenses who are no longer eligible, and that has been removed. importantly in this bill as well. Could talk more about that, but just for the sake of time, wanted to move on to child care licensing. This has raised a lot of questions for providers and especially large institutions or facilities that might have a child care facility on site. Again, this was part of the 2014 reauthorization. The bill provides definitions for child care providers and child care staff members. A child care provider is a child care program required to be licensed under the Child Care Licensing Act. And then a child care, and this is hopefully important for you all to hear, a child care staff member is an individual who is not related to all the children for whom child care services are provided. In addition, a child care staff member is employed by a child care provider, including contract employees or self-employed individuals whose activities involve the care or supervision of children for a child care provider, or unsupervised access to children who are cared for or supervised by a child care provider, or who is residing in a family child care home and who is 18 years of age or older. One question we get is, if you're a large facility, for instance, a hospital, would a janitor be required to get a background check? Would a doctor or a nurse be required with other staff? And our response is no, so long as they don't have unsupervised access to a child. So as long as that person is going to be either part of the child care staff or have unsupervised access, then they would be required to reply or respond to those requirements. So could go on. There's a lot with this. Right now we're working with the Nebraska State Patrol in implementing this new law as it becomes effective here later this year. There's kind of a 2-year phase-in for this. Just wanted to hit that. A child care staff member who is employed by a child care provider before October 1st, 2019, or who resided in a family child care home before October 1st, 2019 shall submit to this criminal history record check. And then October 1st, 2021, unless the child care staff member ceases to be a child care staff member before this date. The other thing that pertaining to FFPSA is background checks for employees or staff in child caring facilities. This one's important because it's again a federal requirement that we have to comply with, and this requires anybody that's staff in a child caring facility to go through background checks. There's a program instruction that essentially says that FFPSA requires that Title IV agencies apply these same procedures for fingerprint-based criminal record checks of national crime information databases and child abuse registry checks by any adult working in a child caring institution, which includes group homes, residential treatment centers, shelters, and other congregate care settings. And then it's important that as we talk about this, that the statute does not allow any exemptions from conducting the checks for any adults who are working in such settings. So this is everybody that's employed in a CCI or will be employed that has to go through these background checks. We are currently, just like the child care facilities, working with Nebraska State Patrol to implement. This had an E-clause to it, so it actually became effective June 1st of 2019, but the remainder of the child care background checks for child care facilities and for transitional child care becomes effective September 1st, 2019. And then the last thing I wanted to talk about was LB 59. This was introduced by Senator Kavanaugh. It changes investigations and reporting provisions under the Children's Residential Facilities and Placing Licensure Act. This bill requires DHHS to review all complaints involving violations of this act, including child abuse or neglect complaints, and then determine whether to conduct an investigation within 5 business days after receiving the complaint. If an investigation is conducted, an investigation report shall be issued within 60 days after the determination is made to conduct the investigation, and then final investigations report may be issued within 90 days after such determination if there's an interim report that has been issued within 60 days after such determination. And so that bill becomes effective as well on September 1st, 2019. And so, again, for the sake of time, feel free to ask questions or email me questions or contact me directly, but I'm going to pass it over. So thank you.
Good afternoon. My name is Jeannie Bradner, and I'm the Deputy Administrator overseeing juvenile probation in Nebraska. The good thing about going last is that most everything's already been talked about already. And as Mary Pat alluded to early on, is there wasn't a lot of juvenile probation specific action in the legislature this year, so I do just have a couple things to follow up on. First and foremost, thanks, a big thank you to Sarah Helvey for the public service announcement that she provided earlier in this webinar. But just to reiterate, the Children's Commission membership terms have ended and the Commission is accepting new application for memberships. And in addition to that, we also have to restructure our executive leadership board. And so if you or anyone that you know is interested in a leadership position on the commission, please have that conversation as well, because we do need to have some leadership on the commission as well. The last two things that I wanted to mention specific to juvenile justice is LR that is on the screen, 176. And actually, I'm not sure, I apologize I didn't get these edits in, but it is not introduced by Chambers, but instead by Senators Kavanaugh and Moorfeld. But this is actually an interim study to examine the juvenile justice system outcomes for youth who are under supervision. The language from the legislative resolution comes specifically from a 2014 publication of the Council of State Governments Justice Center that talks about the different ways in which recidivism and outcomes can and should be measured with youth that are having involvement in the juvenile justice system. And it kind of goes through several different points about what this recidivism data should and could include. And looking at those, not just the recidivism, but other outcomes, including education, behavioral health improvements, skill development, employment, and such things to better measure the productivity of youth who are justice involved. So again, this is a judiciary referred resolution. I have not had contact with Senators Kavanaugh or Moorfeld on this, and I do not believe there has been a hearing set, but we will definitely keep our ear to the ground and be involved in that process if that does move forward to anything more formal. The last piece is, in addition, one of the things that is really exciting for juvenile probation this year is the first year since we've had a service dollar budget, is we have received additional dollars to allocate for rate increases. So we are currently looking at those allocations that are for the next 2 fiscal years and determining how those will be allocated. And it wasn't just probation, but also I believe CFS and Medicaid and other entities. So we are all looking at that individually and also having conversations collectively. So that's a really exciting piece of news for our providers. And that's all I have.
Thanks, Jeannie. Well, that is the end of our seminar. Thank you to all the presenters, and thank you for everybody for listening.